Good morning, everybody. Thanks for your patience. Welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. We have many new attendees to today's webinar, so welcome to everyone. And if you're returning to see us again, thank you as always for your continued support of our webinar series. So currently, you as the attendee are in listen-only mode. However, you always have a voice here on our webinar series. If and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time throughout the presentation. You also received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. For CFPs, CPAs, and others, you may receive 1.5 continuing education hours for attending today. And per my attendance records requirements, please email me your ID number if I don't have it already. And for CFPs only, as always, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I will do tomorrow. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this very simple survey to offer us your feedback about the presentation. We read and value every comment that you share with us. It's also an ideal time to request a consultation with Steve for any planning or document reviews that you'd like your family and you to have. And here at Elville & Associates, we look forward to being a resource to you now and in the future. So briefly, as we have a lot to cover, I'd like to give you a brief overview about Steve and share a little bit about our firm. So I'm going to go ahead and share my screen here and pull up a little bit of information about Elville & Associates. So Elville & Associates, we were founded in 2010 in Columbia by our managing principal and lead attorney, Stephen Elville. We offer many different practice areas and services here at Elville & Associates, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway community location here in Columbia today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do offer a lot of education, and that's something you're going to hear a lot about today. We do that in several ways. Through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20 plus years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year. So congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I'm very privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me, and I'll be very, very happy to share our story with you when we have just a little bit more time. So with all that said, let's go ahead and get started. We have a poll that we always like to get started with to learn just what's brought you to today's webinar. There's a lot of reasons, but we'd like to find out what's brought you here today to learn about estate planning. So I'm going to go ahead and launch that poll, which you should see up on your screen. And the choices are: I am new to estate planning and need to get started. Secondly, I have a plan in place, but it is outdated and needs updating, which is not out of the ordinary. Third, I feel my plan is on solid ground, but education is always great, which it is. And lastly, I'm an advisor here to learn to better serve my clients. So welcome to all, and we'll just take a few seconds to have you make the choice that best suits your situation. And then Steve will take over. All right, another few seconds here. Okay, Steve, we have a varied group here today. 31% say I am new to estate planning and need to get started. 19% say I have a plan in place, but it is outdated and needs updating. Another 19% say I feel my plan is on solid ground, but education is great. And another 31% say I'm an advisor here to learn to better serve my clients. So thanks for participating. And let's go ahead and pull up the presentation, which I have right here. At least I should have right here. Second. Well, let's try one other thing here. Give me just 1 second.
Jeff, while you're getting the screen up there, I'll go ahead and just get started. And good morning, everyone. Thank you for your patience as we work through our technical issues here. So everything's normal in that sense. Happy Wednesday morning to you, and welcome to our webinar series. And it's my privilege to be here with you this morning to educate. And that's what we like to do here at Elville and Associates, is educate clients and their families. So thank you for your attendance this morning. We know your time is very valuable. And after a few brief comments, I'm going to get right into the material. I'd like to thank all the advisors and all of the clients and potential clients and other individuals who are on this workshop. I see we have many attendees this morning. And my intention today is to lead you through a discussion where you'll be able to walk away from this today with some substantive information. I want you to think of this as a mini master class on estate planning and elder law concepts. We're going to touch on several things having to do with tax planning and other issues, but the substance of this is really for me to communicate with you and to lead you through this discussion where you will be able to use this material to your benefit. And I promise that after today, you don't have to remember everything, but you'll probably know about 90 to 95% more than anyone you know about estate planning and elder law. I'd like to thank Jeff, my longtime colleague, who was our community relations director, without whom I could not put on these workshops. Jeff is an expert moderator. Please let him know your questions. Let him know if you're having technical difficulties. He's wonderful and will make sure that I know what's happening with your questions. And we're going to stop frequently for questions, so don't worry about that. And I know many of you have come to this workshop today with existing questions, many times questions that you've held in your mind for quite some time. So I promise, even though we can't technically give you official legal advice, we can give you some very general information about your questions. I also would like to thank all of our associates, attorneys, and staff here at Elville & Associates for their support, allowing me to do what I do, and I could not do it without them. So thank you and welcome again. We're going to go ahead and get started. So today we're going to talk about what estate planning is, and we're going to talk about something important, and that's process. What is the process for good estate planning? So we want to keep that in mind. The other thing we're going to talk about is why a lot of plans are challenged. Why is estate planning sometimes difficult to think about, and what are the pitfalls, and what can we do to avoid that? We're going to talk about very fundamental concepts, wills versus trusts. What is the concept of probate versus a non-probate estate? Elder law, taxation, asset protection. We're going to talk about these issues and these concepts that are really at the forefront of contemporary planning. And then we're going to not only educate, but we're going to talk about how can you get started. How can you get started if you've never done estate planning? How can you get over that hump? We want to provide a path forward for you. We not only want to educate, but we want to provide and facilitate a path forward. And for those of you who have existing plans, we want to help you be able to get those plans reviewed and updated. And for the advisors that are on the call, we want to make sure that your questions are answered as well and take the next steps to gain more knowledge and to meet in person if that's what we should do as we move forward. So thank you everyone again, and now we're going to get into the substantive material. All right, Jeff, let's go to the next slide, please. All right, so again, I'm putting this word out there this morning, process, because we either have a process or we have no process. And with estate planning, we want to minimize the possibility of things being random. That's really the reason for planning for anything, right? So we plan and we want to know why we're planning. We want to have a goal, and we're going to talk about that in the next couple of slides. But we also, again, want to be cognitive. We want to be aware of the possibility that our plans could slide down the slippery slope and not work the way we want. So in essence, we want to make estate planning understandable. We want to make it easy to get started, but we also want to have a real healthy knowledge, a healthy awareness that estate planning can be an uphill climb because we're so busy. We can get a plan in place, and yet we can fail to keep that plan going over our lifetimes. So we don't want to fall off the grid, so to speak, and have an estate plan that doesn't work. Let's talk about a few statistics. The vast majority of people in this country have no estate planning. So I'd say statistically, it looks like about 55% of people have no estate planning. And that can get higher in certain demographics. If we are divorced, maybe it could be as high as 62%. If we are young and we are under 45 or 44 years old, somewhere in that range and younger, it could be as high as 80%. So we know most people don't have any planning at all. And that's not surprising for most people, although it should be. So the minority, we're talking about the minority of people who actually do planning. So our first goal is just to become one of the people who does estate planning. And then our second goal, as we're going to see in the next couple of slides, is to become a person who actually understands that estate planning is not only a process, but it's a life process, and it should not just simply be a transaction. All right, Jeff, let's go to the next slide. So again, I'm going to be intentionally redundant. That's one of the things that Jeff and I have always said over the years. That's what helps people learn. That's what we want to do, is help you learn, not to talk about how much we know, but to help you get some substance out of this presentation. We want you to have a goal. We want you to have a a goal-driven plan. If you can figure out what your goal is, then we are going to help you achieve it. Now, some people will not know what that plan is and that goal is, and that's okay. That's why we facilitate and give you time to think through a process to figure out what your goals are. All right, Jeff, let's keep going. So here are just some reference points. Why would you plan? Well, obviously, there are many fundamental reasons. We want to provide certainty for our loved ones. This is a very, very big concern. We want to have smooth administration. Sometimes above and beyond the certainty part, people want to have more smoothness in the administration. And that just means more predictability, less cost. So some people, if we look at this third bullet point, they want to control the cost of administration. The administration of our estate, if we look at it as a three-step process, as we're going to talk about in a moment, with the administration of the estate being the third process, that can be expensive. So sometimes as we get older, we become more concerned about making sure the cost is under control. Asset protection. Some of us are very concerned about minor children or children with disabilities or adults that are at risk, meaning adult children or nieces or nephews or grandchildren. Well, we should know in estate planning that we can protect those persons. We can protect spouses. So we can protect through asset protection techniques. So we're going to talk about that today. Some people are focused on minimizing taxes, and that's part of a traditional estate planning, is to avoid estate tax, even though today that is relatively easy for most people. But there are other types of taxes, income tax, inheritance tax. So that's a goal. Achieving special purposes. Some of you might be charitably inclined. Some of you may have special issues, things that drive you to do planning. So we want to understand those. And again, we want you to define what is your goal as you think through this on a higher level. Okay, Jeff. Now, I keep emphasizing process, and I also keep emphasizing the possibility of failure. Why do I say that? Well, I'm not trying to be negative. I'm just trying to point out a healthy awareness that we have to look at planning in a holistic way because our world is so complex. Changing circumstances, changing political environment, changing tax environment, changing family environments and health issues. So we want to look at planning as a lifetime process, not just as a stack of documents that we put in a drawer and never look at again, or put them in a safe deposit box or a safe. The average person only updates every 19 years. We know that. So some of you right now may be saying, Steve, you're kidding me, 19 years. That is the statistic that we are aware of that seems to hold up over time, 19 years. And remember, that statistic relates to the people who actually do estate planning. So imagine the folks that never do planning, of course, they're at risk. And of course, the people who do planning, we don't want to be in that category where we're only updating our documents every 19 years. Can you imagine what would happen to most people's plans if they did not update more than every 19 years? So we just want to have a healthy awareness of this. Okay, Jeff. Now, there are two major types of estate planning if we just try to look at it very simply. And that's what I'm going to try to do today, is simplify. So traditional estate planning is, here is a stack of documents for you. Thank you very much, and you have an estate plan. I'm just simplifying that for you. That is what traditional estate planning does. There is no follow-up, no education. We're going to talk about that in just a moment. What we want to do is the exact opposite of that. We want to put a plan in place, be happy with it. We want to have a team of advisors, and I'll talk about that further. And then we want to have a model for our own lives, similar to what you do with the filing of your annual taxes, similar to what you do with your financial advisor, similar to what you do with other things in your life that you are concerned about. We don't want to put our estate planning in a drawer and forget about it. We want to update it throughout our lives. And let's talk about these concepts just a little bit more, and then we'll get into more of the substance of what the documents are all about. All right, Jeff, let's go to the next slide. So this traditional estate plan that I just described, which is really defined as a set of stagnant documents that never change. There's no education of family members. There's no updating. There's no relationship, there's no partnership with your estate planning law firm. This is not the way to go. This is the beginning of all problems in estate planning. So we want to avoid this. I'm not going to continue to focus on this. And Jeff, let's continue on now and look at some alternatives to this. And we'll go to the next slide. Instead, what we want to look at is a multi-step process, not just a one-dimensional process, a holistic process. And it doesn't really matter how many steps. I'm suggesting that there are 3 major steps during life, and that is the design and implementation of the plan. This is where many of you who have not thought about this in quite some time will think through the issue of, what are my goals? What are my values? What are my intentions? Giving the time that this deserves. But then during life, to really maintain this plan, to really make sure that it's not falling apart due to changed circumstances and changes in the law. And this doesn't mean we have to go crazy. This just means that we have to really understand that we don't want to let this go for years at a time. And if we do this hard work and this not so hard work, let's say, if we are in partnership with the right professional advisors, now we have a plan that will actually work when we are no longer here. And if you think about that, doesn't that make sense? That we're controlling the process from beginning to end, and we're not leaving our estate planning to chance. That's what we're really talking about. Let's go to the next slide, Jeff. And in this process-driven plan, no matter what the process is, as long as it's logical, in this process plan, we have education, not only of yourselves, but of your family members and of your fiduciaries. The maintenance and updating speaks for itself. All the beneficiary designations are correct. All the titling is correct. And as we're going to see in this process, all the assets are flowing the way they should. Our intentions are being carried out, whatever they may be. And the process itself is what makes things happen. And hopefully this process is what we call a caring for clients model. This is a process where there's partnership between the client and the law firm, and also the advisory team, the CPA that's involved, the tax preparer, and the financial advisor, maybe even an insurance professional, and in some cases, an elder care professional, such as a life care manager. Okay, Jeff. Let's define estate planning. And I want you to just take a second in your own mind, in your own way, wherever you are, take a piece of paper or your computer, or just think through this. What are your goals and values? What is it that you would be trying to accomplish in estate planning? What is it that you want your family to know or to accomplish? What are your special purposes? I'm going to give you a very simple definition. It's not that personal, but it's very simple. Estate planning is about providing for or disposing of the property to the persons or individuals of your choice, the way you want, if this makes sense, at the lowest possible cost. So think about that. That makes sense, doesn't it? You're disposing of property at your death to the persons or organizations of your choice at the lowest possible cost. Now, this is a very simplistic explanation of estate planning. I want you, again, whether it's now or whether it's later, to start considering, what are those values? What are those things that are important to me? What are my concerns? And how can I address that in my estate planning? What are my goals? Okay, Jeff. Jeff, I'm going to stop for just a second. Do we have any questions yet, or should I just persevere?
Thanks, Steve. Let's take a look here. No questions as of yet.
Very good. All right, very good. So now I'm going to get into the more substantive discussion about the documents themselves and the process of establishment and why. So let's talk about probate versus non-probate. The average person in America, if asked about estate planning, would probably say, I want to avoid probate. But yet so many people don't know what probate is. Many of you on this webinar do know what probate is, and you may have been a personal representative or an executor in an estate. So please take this with a grain of salt if you know what this is. If you've never heard of this, excuse me, if you don't know what probate is, I'm going to take you through a little mini discussion of it. So if we have a will, a last will and testament, that will by its very nature has to go through probate. It has to be proven through a process. Now, our colleagues in Virginia, I'm having lunch today with one of them, tell me that probate in Virginia is very, very nominal. I don't know that's to be true for sure, but that's what I hear. In Maryland, our probate is quite robust, and in New York and places like that, it's quite a large process. So we have to be cognizant that probate is going to prove the will to be valid through a process. And in that process, there's public oversight, and certain assets are subject to probate, but I'm going to get to that in just a second. But there's a process of opening the estate. This is very simplistic on my part here. Assets have to be inventoried, they have to be valued. The claims of creditors can be attached to the estate, so the creditors have to get notice. There has to be an accounting, and the Register of Wills supervises this process. Why? To make sure everyone has notice, to make sure everyone is getting the information that they deserve if they are interested persons. Now, the cost of probate is going to vary where you are in the country. I had a North Carolina lawyer tell me the other day that probate costs about 5% of the estate. And this is the North Carolina lawyer. Now in Maryland, our statutes seem to suggest that the cost can be and usually is around 4% of the probate assets, where in places like California and New York, it could be higher. So we have to just take this AARP information that the average cost of probate is somewhere between 4 and 7%. But let's talk about what the probate assets actually are. Probate assets are assets that are not jointly owned, they do not have a beneficiary, and they are therefore in the sole name of the individual who died, and they are going to go through this process. So many of you know what this is, but let's just have a couple of very simple illustrations. Let's say that someone passes away and they have a joint account, and there's a surviving joint owner. Is there probate? The answer is no, because the surviving joint owner takes that property by operation of law. Let's say someone has an IRA. That IRA has the beneficiary, thank goodness. Well, that beneficiary is an individual. Does that go through probate? And the answer is no. Life insurance has a beneficiary. Does it go through probate? No. But what if the IRA or life insurance had no beneficiary, God forbid? Now we would not only have probate on those non-probate assets, but we would also have a tax problem with the IRA because of the acceleration of income tax. So just touching on something very important, in the post-COVID world, we want to make sure that simple things like our beneficiary designations, that we are double and triple checking those, because we want to make sure to avoid probate, but more importantly, to avoid taxation on IRAs. No small thing in the post-COVID world. Now, let's take an example. Someone dies and they have a rental property in their own name. There is no remainderment beneficiary, so to speak, on the deed. There is no joint owner. That obviously is going to go through probate. So probate assets are certain types of assets depending on titling, and then non-probate assets are assets with beneficiary designations generally or joint ownership. All right, so let's talk about what if we have no will? Well, if we have no will, the individual has died without a will, and therefore their estate is going to go through the intestate estate process, meaning the intestacy laws are going to control. So we don't want to die with no will, obviously, because the intestacy laws are going to control. But remember, whether there's a will or no will, we have to worry about what are the probate assets, because if I have a will but I don't have any probate assets, then there's not going to be any probate anyway. So just get our minds around the idea of wills are subject to a process. That process usually takes, not always, around 9 months in Maryland. And we have to be concerned about what are the probate assets versus non-probate assets. And we want to make sure that our titling or our beneficiary designations is correct, I should say, with wills to avoid probate on non-probate assets. Jeff, let's look at the next slide about what a will structure actually is. Now, as we look at this simple diagram, we see that the will is kind of the center of the universe here. It is controlling everything that is subject to probate. So hopefully we got our minds around that last slide. The will is now accompanied by what? incapacity planning documents. The will is what happens at death. The ancillary documents, as we call them on both sides of the will here, the financial powers of attorney, the advanced medical directives, those are the incapacity planning documents. And when you have these three things, you have an estate plan. Don't let anyone tell you that this is not sufficient. This is a solid estate plan in any measure. So this is the basic structure of a will. Now let's go to a substitute for a will, the next slide, and that is the revocable living trust. And now we're getting to the non-probate analysis. Why would you have a revocable trust? Well, many of you may already have this in your own lives or thinking about it. So a revocable trust has special purposes, you know, where there are family conflicts. We in law tend to gravitate toward a revocable trust for various reasons that are beyond today's discussion. But the main driving force is for someone to say, my goal is to avoid probate, because if we use this revocable trust, which is a substitute for a will, this is not a will, but a will substitute. Now we can avoid probate if we do two things. We have to, first of all, create the trust, which we're going to look at in just a second. And then we have to align the assets. We have to fund the trust. Fund, F-U-N-D. Transfer assets to the trust. These are non-retirement assets. Checking, savings, money markets, brokerage accounts, mutual funds, savings bonds, real estate, even LLC interests can be assigned, tangible personal property. All these things go to the revocable trust, and now we have a revocable trust that actually works. Many of you may have experienced or even know someone who has a revocable trust and they've never done any of that funding. Well, that person just has a fancy will, unfortunately, and their plan is not going to work. So that's one of the reasons why, if we do have a goal of avoiding probate and we're using a revocable trust, we want to make sure that trust is funded. And many of our advisor colleagues on this webinar understand this. This is one of the biggest issues with estate planning attorneys, to make sure they are assisting the clients with the funding of the trust. Even though this is the client's responsibility, clients typically need help in doing this. Now, a revocable trust is not an asset protection device. So if we develop a revocable trust and all it is a substitute for a will, it avoids probate if it's properly done. There is no asset protection. So we want to be clear about that. This is not something that will protect us from the claims of creditors or bankruptcy or bad marriages. It is simply a reflection of the individual. There are no tax savings. So the revocable trust may be a wonderful tool, which it is. It's a wonderful management tool. It's a wonderful alternative to a will for some people, for many people, but it does not save estate taxes. Now, it obviously does not save income taxes either, or inheritance tax. Trust administration, if we have a fully funded trust, if we have walked through those steps of that process, if we have been mindful and educated and we have a fully funded trust, now the cost of our administration, remember when we are no longer living and we've passed along our estate to our loved ones, and we've given it to them in such a way that hopefully it will be that smooth administration that we may have wanted. This is how you do that. And by doing that, the cost should be, and usually is, less for a revocable trust administration. Not always, but if it's properly done and if you've properly maintained that trust during your life, we have the very strong possibility of having minimal administration compared to probate. Jeff, let's look at a revocable trust and what it looks like. So here now, the center of our universe for estate planning is the revocable trust. And you'll notice that the will has kind of receded into the background. So the will now becomes a secondary backup document, and the revocable trust, which we know we have to design that trust, we have to maintain that trust during our life, but initially after the design, we want to fund it with assets. Now, do retirement plan assets like IRAs and 401ks, do those go into the trust? Absolutely not. So we want to make sure we understand that retirement plans are different animals, And those things, those animals are over here in their own corral, so to speak, and they are to be treated separately. Now, we beneficiary designate lots of retirement assets certain ways, and we're going to talk about that next in a few minutes. But we do not retitle retirement plan assets in a revocable trust because that would make you very unhappy and trigger taxation. So we treat these differently, but the goal of the plan is control and also avoiding probate and making sure that everything is properly done. That leads us to this idea of perfection. So what we want to do, if we have this process, we have the education, we have the fiduciaries that are educated, family members that are educated, and the proper advisory team, and that team is communicating, we are achieving perfection in estate planning. All right, let's go to the next slide, and then we'll stop for some questions. Now, we've talked about two ways of leaving assets, but let's not forget this way. This way is the third method of leaving assets, generally speaking, and this is non-probate transfers. Many of you are very familiar with this. Joint ownership, beneficiary designations that we've talked about a lot today. Life estate deeds, you're reserving a life estate in your property, but at your passing, it automatically goes to beneficiaries called remainderment. These life estates avoid probate. Transfer on death designations, TOD. Mr. or Mrs. Financial Advisor, I would like you to make my account transferable on death to my beneficiaries. Well, that avoids probate. Payable on death, you go to the bank and you set up an account. Payable on death, same situation. An in trust for account is very similar in some New England and northern states, similar to a POD or TOD account. These non-probate transfers avoid probate, but we have to understand that if I were to categorize this, I would put this right in the middle. And I would say over here on the left, in my left, is the will-based plan, the probate plan. Over here on the right, or my right, is the non-probate plan using a revocable trust. What are we doing in either one of those categories, the first category or the third category? We are controlling how the assets go. There's all kinds of provisions for contingencies and illnesses and incapacity and special needs and how compensation is handled and how asset protection is provided if there is asset protection, and on and on and on, and how we will either keep assets in trust or not forever. So all kinds of things that we do through the control process of the documents as assets flow down. With the non-probate transfers, we can leave our assets non-probate if all the facts and circumstances are perfect at the time of our deaths. Our beneficiaries and loved ones actually survive us. They have no issues. There are no marital issues. There are no problems. Everything would work perfectly if all the things were to fall into place the way we envision. But the problem is life is usually not like that. So we don't want to rely on these transfer devices as the way to go for our entire estate plan. Instead, in estate planning, we look at this as strategic. If there is a certain strategy that we're trying to accomplish, either for Medicaid purposes or other purposes, then we usually use these tools to achieve those certain purposes. But we don't look at these as the method of actually leaving everything to our loved ones. We instead want to look to the control mechanisms that we need to be able to achieve perfection. All right, Jeff, let's go to the next slide. And this now will illustrate, if we are using these non-probate devices, what can happen? Well, in my example here, and I'll try to give some sense of humor here this morning, you have gone out of your way, you have created this wonderful will, the wonderful revocable trust. These documents are second to none. They are perfection in and of themselves. And you put a lot of time and effort. You put your emotions and your heart into this planning process. You actually stepped up to the plate and you did it. Well, now what happened was, if you weren't careful, you did not take the second step. You didn't actually think about, well, how are my assets flowing? Well, my advisor told me to do this, or I didn't really think about that. Well, now what's happening is, no matter what your will or trust says, no matter what the contingency provisions are, no matter what the safety provisions are, the money, if you look at this chart, is actually going from point A, which is you, to point B, which is the beneficiary. And again, we're right back to that risk. We're risking that everything is absolutely perfect. And God forbid if it's not perfect, we now have passed assets on to someone who has already predeceased us. We've passed assets on to someone who is ill, someone who could have had assets preserved in a special needs trust if they had just suffered a brain injury. We just don't want to do this if we are seeking perfection in our planning. Jeff, let's go to the next slide, which is a similar slide to this one, maybe a little more clear. Here we have the world's best will. We have the best plan in the world. I used to joke that I got in my car, I drove all the way to Manhattan, and I got Jonathan Blotmacher, who I understand is now retired, the world's greatest estate planner. And he created these documents, but my gosh, look what happened when I died. None of my assets flowed in a coordination with the documents, so therefore my plan did not work. We just want to make sure that if we actually do what is on this chart, that we do it intentionally. And if we're not intending to do that, that we avoid the catastrophes that can happen with funding. So funding, or the alignment of assets, is arguably the most important thing in estate planning. All right, now that was literally a mouthful for the last half hour or so, actually more than that. And I'm going to take a break now just to see if there are any questions and to get a little sip of water.
Thanks, Steve. We do have a few questions. First one is, at what age should a person first consider creating an estate plan?
Thank you for that really wonderful question. I'm just going to say that everything is driven by circumstances, right? Most young people, statistically are not going to pass away, and they don't need an estate plan per se, right? Because they're just not going to die. Generally speaking, they're not going to become incapacitated. But let's just think about young people. We have young people going off to college. Do some young people, not all, do some people do silly things when they are in college? They could get injured. They drive too fast. They party at school. I've seen people become brain injured and actually have problems just from. So even very young people should have powers of attorney and advance directives so that they have agents. They sign documents that give HIPAA waivers to their parents. Now let's take another example. As we get older, now that young person or that couple has children, they want to have an estate plan in place to provide for what? Guardians for their minor children. So it's all facts and circumstances, but we're still talking about young people. I would say generally somewhere in the mid 30s at the latest, mid 30s, 35 to 45, we should have an estate plan. If we're a younger person, if we're an older person, we definitely want to have an estate plan for all of those reasons that I just described. But all planning is goal driven. And I think arguably there are certain people who don't need wills if they're younger, but certainly they do need the incapacity planning documents. So I hope that helps. Thank you for that great question.
Okay, next one is, life insurance should not have as beneficiary, quote, my estate, but rather should name a person.
Thank you. And what I'm extrapolating from your question is that, how should I designate my life insurance? Well, we don't want life insurance to be a part of the estate usually, but there could be a reason why, for some relatively small reason, usually not the majority of the time, that we would want life insurance to actually be part of the estate. But generally speaking, it depends on the facts and circumstances. We're going to want our life insurance to have a beneficiary designation so that it's not going to be part of a probate estate when you could have avoided that. That's generally what you're looking for. Now, with IRAs, we definitely don't want those to go through the estate, because instead of the 10-year stretch out, which we'll talk about briefly, or if your beneficiaries are one of the 5 types of exempt persons under the Secure Act, they can have a lifetime stretch out of the assets like prior to the Secure Act. But if we leave it to an estate, we're going to have to take the assets in 5 years or less. And we don't want that, because that generally means that we're not going to wait those 5 years. The personal representative is just going to cash out that IRA all taxation would be due immediately. So we don't want things generally to go to the estate if they are non-probate assets, generally speaking.
Okay, and last one for now is, can a revocable trust be structured to protect assets if your beneficiary gets divorced?
Wonderful question. And the answer is yes. The revocable trust does not in and of itself protect against divorce, but as you just kind of implied, it is a tool. It's a wonderful tool or platform. And at your passing, that platform can create further trusts, which we're going to talk about today, for beneficiaries. And those trusts, if they're properly drafted, they can protect against divorce and the claims of a divorcing spouse. So you can do that under a will. You can also do that under a trust.
Okay, that's all for now. Thank you.
Thank you, Jeff. So now let's go to the next slide, and we're going to transition now into incapacity planning. And this is a tough subject. I'm going to try to get through it quickly so we can get on towards the end of the presentation in a few minutes. But this is a fundamental thing. Remember, I said that when we are doing estate planning, in a very simple way of thinking, we are planning for what happens at death, and we are also planning for what happens during life. So when we have powers of attorney, when we have advanced medical directives, we are doing financial planning in the event of our incapacity. And what does that mean? That means that if I appoint an agent, your agent is the person who is your trusted fiduciary. You are the principal. They are the agent. You are giving them power. You're asking them, please pay my bills. Please take care of me. Please take care of my spouse. Take care of any person who is dependent on me. Now, that's a lot. And for those reasons that I just threw out there to you, the financial power of attorney from an attorney's perspective is arguably the most important of all the estate planning documents. So what I want to emphasize here is that powers of attorney are arguably.
Well, let's see. I'm on a presentation right now.
Jeff? I don't know. Hello, Jeff. I don't know if you can mute yourself, Jeff, but we can hear you. So I apologize about that. So powers of attorney, again, are arguably the most important of all the documents. They avoid guardianship of your property. The advanced medical directive, of course, has to do with healthcare decision-making. For many clients, that is the most important of all documents. So please don't let me suggest otherwise. The advanced directive names agents, and when you have agents that carry out your wishes for your healthcare, you are avoiding guardianship of your person. Now, Jeff, let's go to the next slide, and we're going to see that we are actually going to illustrate this now. This simple graphic talks about powers of attorney. Powers of attorney, and you'll see there are two types here. And in basic estate planning today, we want to be aware that there is something called the statutory power of attorney. This simply means that just like DC, Delaware, West Virginia, New York, Maryland has a statutory power of attorney. What does that mean? That just means that the average person who lives in Maryland now can have assurance that the power of attorney is actually something that works, it's enforceable. If you become incapacitated, you can rely on that power of attorney. The general power of attorney is a broader form. This is something that we would generally design for you as part of your estate plan to give you the kind of flexibility you might be looking for. If we were to sum up what is incapacity planning for financial purposes and why is it so important, it's because you can customize the flexibility that you want to give your loved ones if you become incapacitated. And this could mean access to funds, it could mean compensation, it could mean asset preservation if you were sick and you wanted to preserve assets. It can be avoiding having to go to court to get permission to do certain things, extremely important. On the medical side of things, again, we are appointing an agent, and what are we doing? We're avoiding guardianship of our person. So in the advanced directive, which we're going to talk about in just a minute, we're doing all kinds of things, but the fundamental thing we're doing with incapacity planning, we are avoiding adult guardianship of ourselves. We are basically saying to the world, we have a private estate plan These are our agents who are going to make our decisions for us, and I don't want a guardianship. I don't want to lose my legal rights. I want to keep my affairs and my self-determination private. Okay, Jeff, let's go to the next slide. Now, you'll notice I took a little bit of time there talking about the statutory power of attorney. The statutory power of attorney is a basic document. There is a broader statutory document that Maryland has, but generally in estate planning, we don't use that one because what we try to do with these documents is go beyond them. We want to use them for what they are good for, which is their enforceability and their reliability. But we want to go beyond them and design things that are more flexible for individuals. So many times we use both the statutory form and a general power of attorney. These next few slides, I'm not going to put you through every single one of these. Jeff's going to just page through these. We are trying to point out that the simple Maryland power of attorney does not cover advanced concepts, but it still has a very powerful use, and we want to usually make sure that we have that power of attorney in addition to a more customized companion power of attorney. So hopefully that will make sense to you, that that's the approach for kind of estate planning that we want to have that is more flexible and customized. Now let's talk about healthcare decision making and the advance directive. And as I mentioned just a few minutes ago, this is the most important document for some clients, and it could be you that would say the same thing. There are several types of forms for healthcare decision making. There are Catholic forms and other religious bodies that have forms. There is the 5 wishes that you can see on the internet, which is a type of advance directive. Then there is the Maryland Attorney General's form, which is what we use, and we try not to recreate the wheel here. We try to say, listen, an advanced medical directive should be highly understandable. It should be easy to read. It should be customizable. It should be flexible. And the Maryland Advance Directive does all of those things. Now, it is an informal document. So when you think in terms of this, you don't have to be locked into certain provisions. You can customize this form to any way that you would like, as long as it makes sense. Okay, we want to make sure it's logical and that there's no confusion. But why would you want to customize this form? Just like why would you want to customize the financial power of attorney for the reasons we mentioned? Well, in the healthcare context, your agent is advocating for you. They are wanting to make sure that your wishes are carried out. You are concerned about your wishes being carried out. The only way to really make sure of that is to choose your agents very carefully and also customize your advance directive. Now, you don't have to customize it. You can leave it largely blank. But if we start thinking through these issues, and we at Elville and Associates, we make sure clients are educated about the nuances of advance directives. Even doctors as clients that we have are not aware of some of the nuances that we will bring up from the legal point of view. But let's focus on this slide. Personal input that you can make into your advance directive. Your personal preferences. I'm a religious person. I have certain things I want to say. I have certain limitations that I want to make sure everyone's aware of. I want certain kinds of food. For example, I had a client recently that was in a hospital in another state and could not get the food that she needed. The type of dietary issues that she had were not being addressed. Entertainment, what do I want? Do I want to have my cell phone handy? Simple things. In the old days when we didn't have cell phones, a person could actually be very isolated in a facility by not having a telephone. Some of you may remember those days. My power of attorney for healthcare, when is the agent's power effective? What are my end of life decisions, and do I want to customize those? Do I want to make organ donation arrangements? All of these things, remember, if you don't say these things in the documents, then the only thing that your agent has is what you've told them verbally during your lifetime. So we just want to make sure that you're being clear and you can say it to whatever extent you want by customizing documents. And of course, you do not have to, but we encourage you to do that. All right, Jeff, let's go to the next page. The MOLST form, or the Medical Order for Life-Sustaining Treatment, is something that's in Maryland law since 2013 and actually effective in 2014. It's been around a long time now, but many people understand it, but still many people don't. We encourage you to learn about MOLST because Maryland requires it. Maryland is one of the only handful of states that says if you go into a facility or under certain circumstances, you must have a MOLST form, the medical order for life-sustaining treatment, signed by a doctor or nurse practitioner. And we can help you learn more about this, but I think that you should be aware of it if you're not already. But maybe more importantly, your fiduciaries, your agents should be aware of it, that it exists. And this is something that is not directly correlated with your advance directive, but it's still a very big thing to know about and to maybe even have input in during your lifetime. Okay, Jeff, let's go to the next slide. Now I'm going to shift gears. I'm going to check my time here. It looks like we're doing pretty well. And thank you for your continued attention and being here today. I'm now going to shift gears. We've talked about the process that we need. We've talked about avoiding failure. We've talked about avoiding a process where there's actually no process. We've talked about wills versus trusts. We've talked about incapacity planning. We've talked about non-probate transfers. Now let's get into the estate planning environment. We're still living in what I would just say in my experience, an unprecedented favorable environment for estate planning. We have very high estate tax exemptions, $12,060,000 per person on the federal level, $5 million per person on the Maryland state level. Now, of course, Maryland is one of the only states that has an inheritance tax and a state estate tax, but there we have it, and we just have to deal with it. The current tax environment is unprecedented. A couple can leave over $24 million if properly done without estate tax. We can also give away during our lives up to $12,060,000 per person. Now, these exemption amounts are not supposed to last forever. In 2021, these were slated to go away. We really thought that, well, I shouldn't have used the word slated actually. In 2021, we thought that through congressional action and the political environment that these exemptions were going to go away. Some of us even thought they were going to be retroactive as far as the new exemptions back to January of 2021. But about a year ago, all of that came to a screeching halt in the fall of 2021. So we still live in an environment that until 2026, when these are actually slated, correctly said, slated to go away and be reduced by half of the amount in 2026. So we just want to be aware that this is a wonderful environment for income tax purposes and for estate planning purposes in the current environment. Now, portability, which is the concept that's been around since the tail end of the Obama administration. If you are married, portability means that you now can engage in simplified tax planning to use those $12 million exemptions without having to go through a lot of complex jumping through hoops. And it's something that doesn't look like it's ever going to go away. Both sides of the aisle in Congress don't seem to be concerned about portability. So that's one of the major advantages. And again, to define portability more, portability, if you're not aware of this, is the ability of a surviving spouse to utilize the exemption amount, the $12 million, and the $5 million for Maryland purposes of the deceased spouse without having to jump through a lot of hoops. So it's an amazing thing that we don't think is going to go away. But it's also a time of really favorable laws with regard to asset protection. So someone just mentioned earlier, we had a person that asked a question about, can I leave a trust for children or others that will protect? And in this type of environment, the answer is absolutely yes. We can leave assets in trust for surviving spouses to protect them, not only to protect them from creditors, but to protect from remarriage and the risks of remarriage and whether or not assets could be lost to a new spouse. We also want to be aware of certain changes in the law, which we'll talk about in just a minute, that have to do with protection of surviving spouses and the surviving spouse having to make sure they are not going to be giving away the family assets to a new spouse. And we call that the new spousal elective share that the survivor has to be aware of, that if they don't have a prenuptial agreement with a new spouse where they waive the right of election, then the new spouse can get a significant chunk of the assets from the surviving spouse. So we just have to be aware of these new laws. That 2020 was a big year for that law, as well as the Secure Act, which has to do with savings and taxes. We want to be aware of this. And speaking of the Secure Act, I'll just give a little bit of a preview before the ending slide that really talks about the Secure Act. President Trump signed this at the end of 2019. It was supported by both sides of the aisle, and in 2020 it became law. And many of you are aware of the Secure Act. The Secure Act expands tremendously the ability of Americans to save for retirement. But on the tail end of the Secure Act, it did what many of us are aware of. It limited how much time the IRAs can be left to beneficiaries and how long those beneficiaries can stretch out the taxation. So the end of the stretch IRA, the end of the ability for most people to stretch this out for their lifetimes while the IRA grows tax deferred, that has now been taken away for the vast majority of people. So there are only 5 types of individuals: disabled individuals and their special needs trust, chronically ill people and special needs trusts, surviving spouses I should say, minor children, with the minor being defined as someone who is 21 or under for purposes of the Secure Act, and individuals who are less than 10 years younger than the participant in the IRA or the plan. Those 5 types of individuals are exempt from the Secure Act, but no one else is exempt. All healthy beneficiaries, if you're not in one of those categories, those beneficiaries such as healthy children, grandchildren, nieces and nephews, those individuals are going to have to pay all the tax on the IRA in 10 years or less, and new regulations continue to come out. So these things are part of the fabric of the current estate planning environment. Okay, Jeff, let's go to the next slide. Now, as we continue to go through, and we're moving now into the latter part of the presentation, we are now, having talked about modern estate planning environment, we're now melding into elder law. So we're all getting older, and age does not necessarily have to do with elder law, but generally it does. And for people who don't understand what elder law is basically estate planning with an emphasis on disability. So it's estate planning with an emphasis on disability planning, and also housing, special needs, nursing home placement, assisted living, dealing with the cost of care, Social Security, asset protection. All of these things have to do with elder care planning. So as we now start to just delve into elder care or elder law does have a lot of focus on asset preservation. So how do we do that? Well, you have to divest assets. When we're talking about elder care, we're basically talking about the cost of long-term care. And unfortunately, Maryland is not one of the better states for dealing with the cost of long-term care, but that drives many people to think, what do I need to do to preserve assets from a nursing home spend down? How am I going to deal with this? Well, first of all, let's be clear. We at Elville and Associates encourage you to have a financial advisory team, a planning team, the CPA, the financial advisor, and the estate planning or elder law attorney, and an insurance professional if necessary. We want you to have this because why? Because long-term care costs are very expensive, and if you don't have long-term care insurance, we strongly recommend that you get that product if you can afford it. And if you can't afford that, to get some kind of hybrid product, like a life insurance product or something that can be a hybrid or an annuity product. Because we know that long-term care is like a gaping hole in a lot of people's estate plans. And we don't want a gaping hole the size of a Mack truck to drive through. We don't want that. And we also know that if you don't have long-term care planning, long-term care insurance planning, or a hybrid plan, we know that long-term spending down of the assets for Medicaid is extremely expensive, especially since Maryland does not exempt IRAs from the spend down analysis. So we have to be very careful here. So a lot of people think in terms of, I'm going to divest my assets. I'm going to give away my assets in advance. And many of you have heard about the 5-year rule, the 5-year look period, where we have to divest assets in advance of a crisis for 5 years. 60 months. It used to be 3 years, but now it's 5 years, 60 months. So if we do that, we have to understand the various ways of divestment. We also want to control it. So we don't want to just generally give away assets and lose control, lose tax benefits. We want to, in other words, hit several birds with one stone, so to speak, if we are doing this kind of divestment. And many times we use Medicaid tools such as the Medicaid Trust or the Veterans Asset Protection Trust or other techniques to try to maintain that control. Jeff, let's go to the next slide. Jeff, I think, yes, so this is the next slide, thank you. So as we think through these issues now, and we're talking about divestment, we're talking about what is the difference between elder care and estate planning, part of something that kind of gets into the mix there is asset protection. But then asset protection becomes a very ambiguous word. What does that really mean? Well, I'm going to break that down for you in 3 different categories. Lifetime protection, long-term care protection for asset preservation, that's what we just talked about. And then, as the person mentioned earlier, asset protection at death. Can I leave trusts for my loved ones at death and protect them? So let's get right into the first one. And because we were just focusing on elder care, I want to say right up front here, this one is not a big issue in elder care, but it is not unimportant. This is actually very important. And if you can just bear with me, I want you to think in terms of this kind of asset protection kind of being kind of the normal thing in our lives that we may not be aware of. And we want to kind of juxtapose that against the asset protection that I'm going to talk about for elder care. So tenants by the entireties, if you're a married couple, you enjoy this basic form of asset protection. If you own your home or a brokerage account or any other asset other than an IRA as tenants by the entireties, then a creditor could not get half of that. Creditor could not tear that asset in half and get it. So that is a very basic form of asset protection. Unfortunately, if both of you were sued, if you're married and you lost, then a creditor could get that asset. But it's a very basic form of ownership. We want to make sure that we are titling as many things as possible, generally speaking, for tenants as tenants by the entireties if we are married. Life insurance is protected from the claims of creditors. This is an important thing to understand. If our spouse, if you're married, or children are the beneficiaries. Annuities are protected from the claims of creditors for the same reasons, if your spouse or child is the beneficiary. Qualified plans, 403Bs, 401Ks, IRAs, these are protected generally from the estate, from creditors, I should say, in estate planning. So you don't generally have to worry about losing these assets to creditors. You can't lose your qualified plan, and IRAs are generally protected in bankruptcy. So we want to make sure that we understand that and we have our beneficiaries correct, of course. But note that we have problems for inherited IRAs. So when we pass away and we leave an IRA to a non-spouse, we leave assets to children, grandchildren, nieces or nephews, those IRA assets that are coming down to them are not going to be protected from creditors or divorce or bankruptcy. So we want to make sure that we understand that we can protect those assets, those IRA assets, in further trust, like this nice individual had asked earlier in the question, but we have to be proactive if we're going to protect those IRAs, but we can do it. And then finally, for lifetime asset protection, there are states like our neighbors in Delaware. There are states such as Nevada and Alaska and South Dakota and Wyoming. These are asset protection states, and there's about 16 to 19 of these at any given time. And these states allow us to do a more advanced asset protection if we want to during our lives. All right, Jeff, let's go to the next slide now. We're coming back to elder care. So I had talked about what is the difference between estate planning and elder care. Well, now we know that elder law is the focus, basically estate planning with a focus on disability and a focus on asset preservation for long-term care. And one of the most powerful tools, not just in elder law, but in estate planning in general, is the Medicaid Asset Protection Trust. So if you are curious about this, we strongly urge you to find out more about this tool, because the Medicaid Asset Protection Trust allows you, for the right person and at the right situation and the right goals, it allows you to divest assets, but to still control those assets in a way, and also to make sure you don't lose important income tax advantages in transferring those assets, and also protecting the assets that you did transfer from the claims of children or other beneficiaries' creditors. Now that's a mouthful, but that trust is a hybrid irrevocable trust. Again, extremely powerful. Well, we are here to educate you more about that if you want to know about that. The Veterans Asset Protection Trust is very similar, but different in the sense that it is designed to allow a person to qualify for a veteran's pension. And there are many different pensions. Generally, we are focused on the Veterans Aid and Attendance benefit, which is a tax-free income. But this is a tool to do asset protection and also trigger eligibility for that benefit. Between spouses, and I apologize if you're not married, between spouses, there are asset protection strategies using wills. And these are strategies where one spouse is disabled, has a dementia or a progressive illness. Maryland law has now blessed this strategy, and it's been around since 1993 in federal law. And for the right couple, where unfortunately one of them is ill, the well spouse can plan through a certain type of will or a trust plan that involves a certain kind of will, where assets can be preserved for the ill spouse and they are not subject to Medicaid recovery. So this is a very popular tool. We plan for this kind of thing many, many times in elder care, where someone has a spousal situation and there's a progressive illness. Now, crisis planning, we talked about that, getting ahead of the 5-year period, getting started. If our goal is to preserve assets, we have to divest, and we have to start that 5-year rule, 5-year period. That's called the look back period generally, but I want you to think of it as a look forward into the future 5-year period. We want you, if you're going to do this, we want you to divest assets and know that you can get through the 5 years. And there's lots of discussion around that issue. Using a Medicaid protection trust, usually an asset protection trust. Now, if that doesn't work because we didn't get through the 5 years, it's very important to be educated, and we don't have time to do that today, but in an elder law consultation to understand how spouses can protect each other if someone has not just a progressive illness, but needs a skilled nursing home, how to protect most of the assets under most circumstances in a spousal spend down. But as we look at the bottom of this slide, the rule of halves also says that even if we didn't do pre-crisis planning, we didn't divest assets, and even if there is no spouse and we can't preserve assets with spousal spend down strategies, that a single person could still, under the current law, in most circumstances, save up to about 50% of their assets if there's the right flexibility in the plan and there's the right strategy, and the assets can be preserved at least up to maybe 50% or maybe a little less. Life estate deeds, we mentioned this. This is a simplistic way of creating a situation where you can divest yourself of real estate and still start that 5-year period. Now, this has no flexibility. It's a pretty straightforward, pretty much high risk strategy of giving up control of the asset and giving it away. But this is a Medicaid strategy that you should be aware of. Okay, Jeff, let's go to the next slide. And as we wrap up our discussion about asset protection planning, I've now taken you from normal, or what I would call conventional asset protection that we have perhaps in our daily lives, depending on what our assets are, whether we're married and whether we're tenants by the entireties, whether we have IRAs, whether we have insurance and annuities where our spouse or child is the beneficiary. Then we've talked about asset protection in elder law. Now we're talking about asset protection at death. And this is something that can be structured, whether you have a will, whether you have a substitute for a will, which is a revocable trust. These types of trust for children, spouses, grandchildren, these trusts can be structured where, except for exception creditors, which have to do with Uncle Sam, the IRS, spouses that are entitled to alimony, like divorced spouses, ex-spouses, or child support. Those are exception creditors, and no trust protects against that, except perhaps in Nevada, where there are no exception creditors. But these kinds of trusts that we can leave for spouses can protect, There is something called spendthrift protection, where the beneficiary is not allowed to give away their assets. The beneficiary can be, depending on how you design this, the beneficiary can be in control. Trustee selection is incredibly important. Jeff and I do a frequent workshop on trustee selection. If you would like to know about that, please let Jeff know and he will send you a link. Nothing could be more important today than, if we're leaving trusts, the trustee selection. Powers of appointment and trust protectors. These are features that can be added. The trust protector feature is something I'm particularly excited about over the last many, many years, and especially in Maryland since 2014, that the trust protector can be the game changer that actually allows you to leave long-term trusts, if that's your goal, for children or others, spouses or others, and also having flexibility in that long-term trust. And of course, we protect a lot of persons with special needs and disabilities. So that is basically the whole scope of asset protection, from lifetime to Medicaid type or long-term care asset protection, and now asset protection at death. All right, so as we start to truly wrap up the presentation now, we're going to go to the next slide. And as I mentioned, the Setting Up for Every Community Retirement Enhancement Act, or in other words, the SECURE Act. Again, I mentioned that this was signed into law. This is a very big thing now, and most of us are becoming much more educated as time goes by. The IRS had its most recent regulations in February of 2022. There are some exceptions, and we need to maximize those exceptions. There are strategies that you can go into greater depth with your advisory team about how to do Roth conversion, or how to, whether or not Roth conversion is a good idea, how to get life insurance in place to take care of these accelerated taxes, where the beneficiaries in most cases are going to be paying taxes in an accelerated basis. All plans should generally be reviewed when it comes to the SECURE Act. And before I go towards the end here, I want to mention one of the things I did not mention, which is a new law in Maryland that actually has to do with incapacity planning and self-determination. So I'm backtracking for just a minute before I forget it, and that is the Supported Decision-Making Act. So the Supported Decision-Making Act that just was passed and became law on October 1st, you need to be aware of this. It is a law that allows a person with disabilities, whether they're young or old, whether they are aged or whether they're cognitively impaired, it allows them to make their own decisions with a supporter to whatever extent that they can. So this is one of the big issues of 2022, and you need to be aware of that. And even though it won't affect many of you on this call right now, it could affect you in the future, and it's something that we're going to be doing an upcoming presentation on. All right, as we truly wrap up, Elville & Associates has a client care program. We are one of the only firms in Maryland that has one. And what we're trying to do here as we page through these slides is simply encourage you to update, because remember, we want to have a process as you start to think about your estate planning, and we want to give you a process that you can actually embrace. And all we're doing in the client care program, again, is encouraging people to update their documents and not let 20 years go by between the time they do their planning. And Jeff, let's just go ahead and get to the end of the presentation in the interest of time. I thank everybody for their attention. We want you to set a consultation with us. We don't charge for estate planning consultations, and generally we don't charge to review existing documents unless they're more complex situations. So there's nothing to fear. We know that this is a big hump for a lot of people to get over. It's not an easy thing to do, to share personal information with people you've never met before, but we want to encourage you to relax and know that we are here to educate. We are here to help you. We want to provide resources for you. We have state-of-the-art facilities here. We have 4 conference rooms at our Columbia office, and we have some outlying offices, but we have great technology here to be able to talk you through issues. We want you to bring your documents, bring your existing documents. I know a great percentage of you have existing documents. Bring them in and let us review them for you and give you our opinion. We're happy to do that. We want to help you form an advisory team if you don't have one, or if you only have one person of the advisors, you don't have a CPA or you don't have a financial advisor. We want to help you put that team together, and we want to make sure that team works for you. We want you to bring your questions. Please feel free to write those questions down, and all of those things that you're concerned about. We encourage you again to come in and relax, use our technology, use the resources that are available to you. Let us help you find out what your goals are. And that's our last bullet point here. Many of you just need time to think. We are very, very busy today. I don't think I've ever been busier, and I'm sure you feel the same way. We want to give you the time to think that you need to come to some conclusions. If you don't know what your goals are, let us help you through that process. If you just simply sit through a process and you participate in that process, you're likely going to have an epiphany about what is important to you and what isn't. And then I know many of you already know what these things are. So thank you so much for your time and attention. Jeff, I want you to wrap up, and I thank everyone here today for being with us on this Wednesday morning.
Well, thank you, Steve. As always, really great information. And thank you to our attendees for being here today and wanting to learn and take in everything that Steve has to share today. And thank you for your questions as well. We do have some questions. And also, very briefly, I want to just say I'm sorry for that jumping over and speaking over Steve for those few seconds there. With a couple of kids at home sick and with some contractors working on my kitchen and finishing up today, I took a call and did not realize I was not muted. So something that I promise will never happen again and never has happened before. So my sincere apologies for that.
Soon, Jeff.
So my sincere apologies for that. So let's jump back into the questions here. We have some good ones here for you, Steve, before we wrap up. The first question is, do you have to use your state's advanced medical directive form? I live in Virginia. Can I use the Maryland Attorney General's form?
That is a wonderful question. Thank you for that. I'm just going to say, first of all, I'm not barred in Virginia, so I certainly cannot give legal advice generally or even about Virginia, but I would encourage you to most likely use your Virginia form. Now, this is just general observation. Because you live in Virginia. I would talk to a Virginia attorney and really find out, can I customize this? Steve said in Maryland that you can customize advanced directives. I'm fairly confident that you can do that in Virginia, but I would strongly recommend that you use your form in the jurisdiction where you live. However, that Virginia lawyer may also tell you that you can use the 5 wishes form or another type of form. So I would go and venture to say that you're probably not locked into that particular form, but I would not necessarily use another state's form. I would use a very general form if you were going to depart from the Virginia form.
Right. Next question is, how can we determine if someone is qualified to set up this estate planning? I'm assuming that she is alluding to if an attorney is qualified, but if, ma'am, if you could maybe let us know if that is not what you are alluding to.
That is truly a perceptive question, and I'm going to say, in answer to that, if you will let us know your information, Jeff can send you a link, and you could watch our webinar on achieving perfection in your estate planning.
Great idea.
And Jeff will send that to you. And I think that's the best way I could answer your question. Many of us get involved in situations in life every day, whether it's who can fix our car, or who should we use as the realtor to buy our house, or who should be our financial advisor. And what happens is we are sometimes subject to good advice. Sometimes we're subject to randomness. And what Jeff and I are doing in that other webinar is we are putting information out that has to do with avoiding randomness in the selection. So there's a criteria, there's certain things you could be thinking through, and I promise that webinar will give you further insight into that very, very important question.
It is. Next question, I'll let you peel this one, peel the onion on this one, Steve. Is it true if you write a will and send it through the mail to a child and they do not open it until death of a parent, is this a legal document?
Well, thank you for that. I really don't know how to comment on that. I will just simply say that a will that's validly executed in a state is, by the full faith and credit clause of the Constitution, valid in any state. And if we are worried that you might be living in another state, which is kind of beyond your question, we would make sure that we try to make sure that the attestation clause of that particular state, or that we take into account that some states have additional attestation beyond what Maryland requires. But generally speaking, a will is valid in any state once it's validly executed in that state.
Right. Next question, if a child inherits a traditional IRA from a parent, must distributions be taken in years 1 through 9 after the parent's death? If a Roth, must distributions be taken in years 1 through 9 as well?
Thank you for that question. So the latest regulations seem to suggest from February 2022 that Uncle Sam wants to encourage people to take those nearly equal distributions over that period of time, so that everything is out of the IRA by the end of the year 10. So I would say the answer to both of those, based on my interpretation of the new February regulations, is yes.
Okay. Is life insurance protected if a beneficiary is not a spouse or a child?
Well, that's a great question. In some states, the answer might be yes. My understanding is in Maryland, the answer would be no, generally. And again, this is not legal advice, and we would have to look into that issue a little further. But generally speaking, I have seen situations where the law is very clear that if the child or spouse is the beneficiary, it's protected. And I've seen situations where someone had gotten upset at their spouse and removed the spouse as the beneficiary, had no children, and the entire life insurance policy, and in that case, many policies, were subject to the claims of creditors in bankruptcy because of that. So generally speaking, that's my understanding.
Okay, and the last one for now, if you do have a last question, we're at 11:30. Please get that into me right now. It'll be a great time. Last question is, I live in DC. Can your practice assist me?
Thank you for that question. So I personally am not barred in DC, but we have attorneys at Elville that are barred in DC, and we can do estate planning for you in that way. Thank you.
Yes, absolutely. Okay, so thank you for all your great questions as always. They help everybody on the presentation. As always, for those of you that are new to our presentations, I will be sending out a very substantive follow-up email that will have links to a lot of our presentations that are ancillary to this presentation that you might want to review, some follow-up information from some of the topics that we've covered today, schedule for our upcoming webinars that hopefully will be very helpful to you. As we look ahead very briefly, we have our wellness series tomorrow, Know Your Why, Fulfillment versus Busyness. On the 4th of November, Steve will be back talking about what elder law attorneys are advising clients in 2022. And then on November 10th, we have a very important presentation Steve alluded to, supported decision-making for loved ones with disabilities. So we've offered that in person at a couple of places already, and we are doing that by webinar for the first time. I think that'll certainly be one of our largest presentations to date, and are very much looking forward to that. So I'll have information about all those in my follow-up email, which I'll send out this afternoon. So thank you for being part of the Elville webinar series. We look forward to meeting you soon and being a resource to you, and we will see you again soon. Have a wonderful day, everybody.
Thank you.